continuing with, we've now identified the problem of the involuntary administration of psychotropic drugs to persons who are not a threat to self or others, who have not actually participated in anything that can justifiably be construed to constitute bizarre behavior, to seek a writing utensil and a piece of paper in order to file a federal habeas corpus. There is no situation in which a person could ever be detained in which it would be justified to prioritize the rule, protocol, regulation, practice of some entity on some city block anywhere in America that would take precedence over federal law. In this particular case, I was a pretrial detainee, or if a person was a post-conviction detainee, then his remedy would be under 18 U.S.C. 2254, 2255. But in my particular case, the federal habeas corpus applied as a pretrial detainee under 18 U.S.C. 2241. There is no situation, again, in which that remedy is not available to anyone who has been accused of a crime from the time he or she is taken into custody. Habeas corpus is applicable, and whatever the governing entity is which is responsible for the detention of a given detainee, that entity is subject to criminal and tort liability for neglecting or failing or for what otherwise not providing the means to file a federal habeas corpus, so that a federal judge can make an adjudication as to whether or not the detention of a given individual in a given configuration of circumstances is compatible or incompatible with the protections guaranteed to all citizens of this country according to the Bill of Rights of the United States Constitution. So, getting back to what are some of the remedies then which can be used: accessing the grand jury, and then when your prosecutor for your particular federal jurisdictional area refuses to present that to a grand jury, to file a petition for mandamus. If the mandamus is not granted at the district court level, to then take it on. To then file an appeal of that, and if that is not granted, take it to the Supreme Court of the United States. One can also go directly to the United States Supreme Court on what's called the Supreme Court Rule 20 petition for the issuance of a special order. That's Rule 20, the United States Supreme Court rules, so that one can circumvent a lot of the bureaucratic paper shuffling to try to get the remedy sooner rather than later, because this, again, is deadly, okay? Now, besides that, that's a criminal provision. There's also state laws that prohibit, it's a medical battery, it's a Class A misdemeanor in the state of Illinois, and so that's a state remedy, which evidence can be presented to a special grand jury or an information. An individual could proceed on an information because it's, at least in the state of Illinois, it's a Class A misdemeanor. Beyond that, one can also seek to decertify the members of policing entities who would participate in this. In my particular instance, I explained to the Cook County Sheriff's deputies who were being used to, they told me when I refused to take Depakote, they told me that I was going to be administered with some other drug, and I then objected, and they told me to put my hands into handcuffs, into restraints, so that I was going to be injected with it, and I complied at that time. I didn't know what the drug was. I voluntarily complied, but there were no claims to consideration that were waived, relinquished, or otherwise forfeited, because I made it unmistakably clear that I was only complying under protest, and I didn't see in these circumstances any other legitimate alternative at that time. I'll explain what some of the other legitimate alternatives are now that I've done more research on the issue. But at any rate, so the point I'm driving at is it can't, one, in that situation, it's necessary for one to lock the individuals who are incurring liability by participating in this, from the sheriff's deputies who are taking a person's hands and detaining him and putting him in handcuffs or otherwise restraining the individual, subjecting him to the involuntary administration, the person who's dispensing the drugs, whatever, if there's a pharmacist involved, if the doctor who allegedly required it, anyone and everyone who's involved in that chain of command, the person who's responsible for the facility, are all incurring liability of various sorts. To prove criminal liability, it's necessary to prove all the elements of a crime beyond a reasonable doubt, which means one has to prove state of mind, that they possessed, the individual possessed knowledge. But it's not futile by any way, shape, or form by serving documents, conducting discovery, serving proposed verified statements, and then getting individuals' responses to what you're doing. Many times you can inferentially prove your case. Use the example of Merrill versus Sheehan, which is a United States Court of Appeals 7th Circuit case in which Kenneth Ripple, in the concurring opinion, which really echoed to a large extent Frank Easterbrook's majority opinion, that there was conscious avoidance by the sheriff of the problems that were being encountered in that particular Joe Merrill's stay in the Cook County Jail. My point here is that this idea that they can't be brought to justice, there's nothing that can be done, no, that is not the case at all. It's indispensably necessary that those of us who know what's happening stand up and use the means that are available. So there's another means, is to conduct civil discovery, to sue civilly, to seek to get an injunction to prevent the forcible administration, involuntary administration of psychotropic drugs in your federal district court. There's also, if it's a state facility, in the state of Illinois, for example, one can move to file an injunction to disperse the continued disbursement of state funds for a given purpose. In this particular case, if there's any state actors involved, for example, a state judge, one can move to disperse the continued disbursement of the compensation that goes to his compensation and benefit package of the state funds. So these are just a number of alternatives. Ultimately, if there's no other way to resolve the matter, there's nothing unjustified about a person simply escaping, endeavoring to escape a given incarceration arrangement. And there's nothing morally unjustified in any way, shape, or form, especially if what is issued becomes a life or death issue, permanent brain damage, permanent eye damage, not only in an endeavor to escape, but there's nothing morally unjustified in using non-excessive or non-otherwise unjustified force to accomplish that escape. And beyond that, if the problem gets to be so bad where it becomes like Stalin's death camps, where they take all of the FEMA red listers, if you will, all of the non-capitulators, all of the people who are refusing to accept the New World Order's enslavement and extermination agenda, then it would come down to there would be nothing morally unjustified in conducting rescues of people who are being detained and kept in morally unjustified arrangements. So I have run out of time here, and it's time for the next person to speak, but there's much more on the website of the Demonstrably Non-Counterfeit Roman Catholic Protection Network, http://www.geocities.com/thirst for justice. We're out here, we're going to fight this to the end. We're going to correct this problem. It's just part of a much larger problem with our court system, which has been a collapse of the entire rule of law, and we are now being subjected to despotism as the country descends into ever deeper barbarity. It's the duty of all able-bodied people to stand up and fight back against this. There is no alternative. The alternative is total enslavement. We can't accept that. I can't accept that. The children deserve more. His Majesty Christ the King deserves that we stand up and use the means that Providence has provided to fight back against these evils.